Thank you for tuning in to Terani Law Firm's presentation of the criminal process overview. Once again, please remember that you should always hire or at least consult a criminal defense attorney and never rely on anything you hear or you read from the internet or anywhere else. You always need the expertise of a criminal lawyer to guide you throughout this process. This is just a basic overview for you to get a feel for what to expect if you are charged with a crime. Should you ever need assistance, you can contact us by visiting our website www.criminalattorneyusa.com or 888-3USA-LAW. That's 888-3USA-LAW. Here we go. The commission of the alleged crime. A group or an individual allegedly commits an act that violates the law. Either law enforcement witnesses this act or somebody else witnesses this act and contacts law enforcement. The pre-arrest investigation. Law enforcement conducts an investigation to gather information and help determine a possible suspect. Law enforcement will gather physical evidence and conduct witness interviews if necessary. This is the time to have a criminal lawyer on your side. If the client has not been charged with a crime yet but is being investigated, our criminal law firm can help shut down the police investigation and help our clients avoid jail if at all possible. You can read more on pre-file investigations on our website www.criminalattorneyusa.com. The arrest. After police have discovered probable cause or a reasonable belief that a crime has been committed, they will take the suspect into custody. The Miranda rights, you have the right to remain silent, anything you say will be held against you in a court of law, do not need to be read at the time of the arrest. Rather, the Miranda rights are only required to be read before a custodial interrogation is conducted. That means you are in custody and being questioned. If you are free to leave, you are not in custody, and therefore your Miranda rights do not have to be read to you. This is a common misconception. To learn more, contact us at www.criminalattorneyusa.com. Booking. This is when the suspect is taken to a police station and asked a series of routine questions such as name, address, tattoos, gang affiliations, so forth and so on. The post-arrest investigation. The investigation conducted before charges have officially been filed. The post-arrest investigation differs from the pre-arrest investigation in that the focus here is primarily on building a strong criminal court case instead of just getting enough evidence to make an arrest. Again, the district attorney is the person who makes the determination of filing a formal charge. Making the decision to file charges. The only person who can file a charge is a district attorney. The police may not file charges, nor may an individual or an alleged victim. Filing the complaint. As mentioned, the prosecutor files a document with the criminal court formally charging the individual with the crime. The review of the complaint. The judge or magistrate reviews the criminal complaint in order to determine if the arresting officer had a good reason to arrest the suspect and charge him or her with a crime. The first court appearance, also referred to as the arraignment. The judge will read the official charges against the defendant and also read him his rights. Bail is set based on a number of factors, including the seriousness of the offense, how likely the defendant is to flee the area, and other factors such as ties to the community. The DA has the right to add more charges to the complaint at the arraignment or even request to have the bail increased or have the defendant remanded back into custody. That is why it is crucial to have a criminal defense lawyer on your side at this hearing. In most juvenile cases, the first court appearance is called a detention hearing, and there is no bail. Instead, the judge will determine whether or not the child should be released into the custody of the legal guardian or parents or be detained, hence a detention hearing. The preliminary hearing. In felony cases only. The purpose of this hearing is to determine whether the evidence is sufficient to continue with prosecuting the alleged criminal in a felony case. Basically, the court is determining whether or not there is enough evidence to find the defendant guilty at trial. Plea bargaining also takes place during this phase. Filing of the indictment. At this point, no plea bargain has been agreed on, so the case moves forward to trial. The prosecutor files the charges or the indictment with the trial court. The first appearance in trial court, also commonly referred to as the arraignment. The defendant is taken before the trial court and informed of the exact charges against him. Defendant pleads guilty, not guilty, or no contest. This is very similar to the arraignment that was described earlier in this video. The only difference is that this arraignment is in the trial court. Pre-trial procedures. Motions are filed by the criminal defense attorney and the district attorney during the trial setting. The trial. This is the part that you see on TV and in the movies. Each side is given the opportunity to make an opening statement, question witnesses, cross-examine opposing witnesses, and make a closing argument. The jury will decide guilt or innocence. Sentencing. This is the hearing for the judge to determine the punishment of the guilty person. Appeals. The ability for the convicted person to make sure the trial court did not make any legal mistakes. Appeals are very complicated, and we urge you to contact us to learn more. www.criminalattorneyusa.com. Expungements. Some who are convicted of a crime may remove the conviction from their record if they meet certain requirements. This is the end of the criminal process overview. Please remember that this is a very basic summary, and there are many facets of the criminal process that have not been covered. It is important to note that each state has its own criminal procedures, and what you have learned may not always apply in every case. To learn more, you may visit our website at www.criminalattorneyusa.com. Thank you.